Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all the little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. Hey everybody, how are you? Happy Wednesday, happy live stream, my best day of the week. Anyway, for anyone who's not here normally, welcome to All Things Social Security and our weekly live stream Q&A. I see some people in the house. This is so nice. Hey, just give me a quick hello that you can hear me. Dimple, can you hear me? I see you down there at the bottom of my comments. I see Shiloh. I see Kevin Johnson's in the house. George Graham. Hi, guys. Good to see you guys. All right. Shiloh says, yes, you can hear, right? All right, perfect. Just like to double check that first thing. Just also a quick heads up, guys, that tonight, 8:45 Eastern time. I'm in the north. Jonathan Ginsburg's in the south. I'll be on with him tonight. That is the plan. I just got to make sure I can stay awake long enough. If I keep working until then, I mean, a lot of times I'll be working till like 10 anyway. It should work out fine. Usually my work at that hour is very silent, and I'm usually working on briefs or something like that, or reviewing. But yeah, so that'll be fun. I haven't seen Jonathan in a number of weeks, so we'll do a little collaboration there. So come join. Let's see. Where should we start? Looks like George is at the top. So George, thanks for getting here early. We have George. Hello. He's one of our, not mine, viewer, but prevailed in his claim. So he's got some little experience there that some of the rest of us might be, hoping to get to. George says, hello, question. Say I just turned 66 and want to volunteer or work 12 hours a week while still on SSDI. Do I need to file for ticket to work, or will SSA not give me a CDR age 67 is near? Yeah, I wouldn't. You're not earning any money. You're not doing SGA work, probably by and large. Even the value of what you're doing for 12 hours a week would probably not normally pay more than whatever SGA is this year. What is it? I'm always looking at the 1620 number. So I wouldn't be concerned. And it is not work, and they're not asking you for anything. It'd be different if you were doing a kind of, I suppose it would be different if you were doing high-end work for an entity where the value of what you're giving is SGA, and they could transfer that into work that would be over SGA. Like, let's say you were a lawyer doing something that would normally cost, $300 an hour, and you're donating 5 hours a week. I don't know, maybe then they would, if that's something that could otherwise be paid for. It doesn't mean, even though it might be worth that if it were paid for, if there's not a market for it, and that's why the person's volunteering. So I wouldn't be too concerned about that. And I definitely am not concerned about a CDR since you're so close to 67. So I wouldn't worry. Okay. And I hope you enjoy volunteering. You can also work a little bit for money, and particularly at 67, when your SSDI automatically flips over to retirement and you are no longer on the ranks of the disabled, you can certainly work and earn as much as you want. So that's the good part about that. All right. Kevin from Tennessee. Hi, Kevin. Shiloh says, and here's the next question. Thank you for your time. If you had a severance agreement with your job due to not being able to continue to work due to PTSD, for instance, should I put my onset date the day after my last day of fulfilling working? Yes, I would. I would put it's when you stopped working, not when you got a paycheck that would equivalent to 6 months of work thereafter. It's when your work activity stopped. Okay. Remember, there's multiple questions and how the SSA asks it. I assume you're talking, Shiloh, about an application, maybe? You'll see. I actually had a video on this not too long ago, the different ways that they ask about work dates and how to look at them all on the application. Because they do ask different ways. When do you think you became unable to work? When did you stop working? And there's a third way. And it is to see if when you stopped working, maybe you actually were disabled under the rules before then, because maybe your work was not SGA. Maybe it was not SGA in gross hours or amounts. That's one thing, some sort of part-time work. And also it could be that it was, even if the money was over SGA, they also give you the opportunity to say, yes, but some of that stuff was impairment-related work expenses. So I could just subtract that from my countable earnings from work, and it might drop a person below SGA, and then they can actually pull their alleged onset date further back, which might potentially be found to be substantiated by the medical evidence. And then they could have 6 months more or a year more back benefits, which would be super beneficial to most of us, right? But yes, I would say unless you're working very part-time and under SGA, Shiloh, before that last day of fulfilling working. If you've been working part-time before then, you might want to go back even further for your alleged onset date. Shiloh has another question. If I could get it to click on, would be good. Would you upload the settlement agreement to show, one, the last day I worked, and two, show the money I received after wasn't due to work but due to something? No. Just tell them what day you stopped working. If your company sent you money after, it will generally be in a 1099 possibly, or a W-2. And usually it'll have a little notation in it that says what it was for, that it wasn't for work activity lining up with that. I wouldn't send them your private settlement agreement business. And I don't know what you were settling on. I know some people are like, well, I settled because I was discriminated against, and that's why I got fired. And for purposes of SSDI, why would you share that? Well, because they feel like they're justified in something, and therefore I've been through this hardship, and therefore I'm a good person. I don't know why. Because you're now, by putting that forward, by sharing what was not asked, you're just basically telling the SSA, I didn't get fired because my disabilities were not making me, because they're bad people and they discriminate against me. But I was able to do that job. Because remember, for disability discrimination type of claims, it has to be where, like, let's say a reasonable accommodation that would allow you to be able to do the job. Still not be able to do the job, but we got to keep paying you anyway, even though you're doing a crappy job. So when people, they want to fight that I was a good worker, I did really, really well, and it wasn't even just that they got rid of me. Well, what are you trying to say? That you didn't become disabled and therefore couldn't do your work? Or you are? It's almost like they're fighting their own case because of this mindset, that they have. So, pardon me. I have my fan on because I don't have air conditioning in here. And we've had some nice warm piping days, but it blows the hair in my face a little bit. It's not even on very much, but I'm trying to keep a little. So I wouldn't do the settlement, Shiloh. I would, A, your statement should be more than enough. B, your last pay stub should show something. And if you don't have a subsequent pay stub that shows something else, like here's my last pay stub. And then if you get something at the year end, it should kind of describe it. Sometimes with those payments, there'll be a letter that says it, not a settlement, but it'll say, here's your severance pay. And you could also probably ask HR for a date of last worked. And then they'll know that this was the day of last work. All the other monies are other vacation or pay or, vacation, disability, sick days that you didn't use that you're entitled to get paid for if your company does it that way. So there's other ways to do it. I just wouldn't let them get in on if it's a different kind of legal battle like the one I just mentioned, because I can come and present a different light. Shiloh says, this is the next question. I know you stated 8 hours of working, sitting, walking, standing, 8 hours of work. But just to make sure I got it, stooping, crawling, etc., that isn't included. No, if you look at the work history report, and if you're doing the application and you only had one job in the past 5 years, you're going to see this on there too. Otherwise, you won't see it. It won't be triggered. And you'll have to do a full-blown work history report. Work history report, the application, when they ask about that job, it even says, just for the sitting, now they combine standing and walking, which makes things much easier. They didn't used to do that. So the standing and walking, so on your feet versus sitting, those two things should, if it's a full-time job, if it's an 8-hour day job, should total 8 hours. And that's by and large makes sense. Now, being on your feet, standing, you could be standing in a squat position. You could be standing in a bent over position or stooping or whatever. So all those, it doesn't matter. That standing and walking that you talked about is all the time on your feet. Those are separate. I would, if you're sitting, they probably wouldn't include those, but they don't get too nitpicky because I know work can be variable. Some days, you could be crawling up to an hour, but some days it's only 2 minutes. Like let's say you're a preschool teacher or a daycare center and you have to watch the babies, and sometimes you have to crawl under the cribs to get the little binkies that fell out. Some days you're like maybe feeling like you're crawling under there all the time, and then other days you just did it once or not at all because no one tossed their binky out. I'm just giving an obvious example of someone who has to get on their knees probably quite a bit and do some crawling. So sitting, standing, walking, make that your 8-hour divide. The rest of it can be kind of whatever it is. And I always say, go for the maximum of a not unusual day. Like on any given day, if there's 5 hours of kneeling that's needed for that, let's say it is that little daycare center job, and you have to be able to be on your knees quite a bit. There's going to be no set time. But if that job says, you have to be on your knees for 4 of those 8 hours because you're playing with the kids, you're going under a crib or what have you, that's what you have to be able to do, then I would probably put 4 hours. It can be up to 4 hours. They don't really give you they don't give you a range if you notice. So then I would go with the one that depicts what your job required. it required that if needed, I had to be on my knees for 4 hours. Didn't mean I had to do it every day, but, and sometimes at a hearing, the judge will say, but really, how often did that happen? And the person might say, well, that only happened maybe once every 2 weeks, but that's where the details can be fleshed out. But if it's like, yeah, no, I'm expected that if it's a 4 hour day, I got to do it for 4 hours. So I can't be like, no, this is my 5 minute day. Let the kitties go wander themselves. Responsibilities are responsibilities, particularly when we're dealing with other human beings. Shallow goes on to say, so this is the next question. My job was computer service, but I did about 5 jobs, customer service. Did I say computer? I did about 5 jobs under being a rep. They said due to that, it's considered a composite job. Ooh, composite jobs are usually favorable for you. Can you explain that more? Is it worth me explaining that? No. So I think you're saying, did you have your hearing and they said it was a composite job? Refresh me on your history there, Shiloh. I don't recall. Yeah, a composite. I just tried to argue one was a composite job in the last couple of months at a hearing, and the judge was like, didn't even want to broach it. But it was a composite job. It was like 50-50, but they wanted it to be all the one side so that it was an easier physical job. That helps them deny it under a grid better. Not that I think he's denying her, but it might, it will take a different avenue. But I thought clearly it's a composite job. The title shouldn't matter. If someone's called a buyer, but half the time they're stocking shelves, for that company and running the storefront, then that seems to me like a composite job, but that's just me. And I'm not an expert on composite jobs, but my information on that. So if they're saying you had 5 jobs kind of all in that role you played, sometimes you had to go get coffee for the boss. Sometimes you have to do that. So you were the one that had to clean the toilet. Like at the end of the day, make sure the bathroom's cleaned up. Those are things that I think add to, particularly if they take up more than like 20 minutes of the day, a composite job. And the beauty of a composite job is they can't take the one big job you had, the one that has the name, because you had to do all these other things, and then assign that to you as to past relevant work that if you could still do. Because you're like, no, that isn't what all I did. I had to do this. This and called, sometimes I had to lift a 5-gallon jug of water because I was responsible for keeping the employee water station stocked in the water cooler. So that was every 2 days I had to lift a 40-gallon bottle of water and carry it 20 yards from store, stock, word stock to blah, blah, blah. Those are all the things that, I would try to add in, because then you're more of an assistant, an admin assistant that has to do all those things. And maybe you're doing the other stuff less than full time. Maybe that other job that you're titled as, you're only doing that 5 hours out of the 8 hours because 3 hours a day you did all these other things. Maybe you were doing, like you said, you were doing customer service, but there were other things you had to do. And that's not unusual for companies to, save money. And I get it, save expenses. Like if you have 5 employees and are you going to hire a 6th just so that they can make sure that the toilet paper is still on the roll so that if a customer needs a bathroom, there's toilet paper. So that one job might be housekeeping, but they're going to make one of the 5 people that are doing the, reception work or whatever the job is, do that too. So they don't have to hire a 6th person to do something that takes 5 minutes twice a day. And when all that stuff adds up, it could turn it into a composite job, I believe. Never hurts to make the argument. Hey, Oscar, how are you doing? Hello, thanks for all the great content you put. Oh, thank you. Good talking to you. Shiloh again says, this is the next question. And I appreciate the questions, by the way, Shiloh, because people get a little slow asking questions when we first start out. So that's all good. Don't feel bad about asking a lot of questions. Shiloh says, how does SSDI view receiving unemployment benefits for about 3 months and having a settlement agreement due to not being able to work? It's from the same job and haven't worked since. Okay, so 2 different things here. Currently, under the law, and I don't think any state has changed their side of it, which is the unemployment side, and neither has the SSA rules. Receiving unemployment doesn't get offset or anything with regard to, so let's say, let me give this scenario, guys, for everybody else who, you stop working because you have an impairment that prevents that job. Maybe that job, you had to lift 50 pounds and now you have a back problem and the doctor says you can't be doing that. All right. So you have to either get let go or you resign for good cause from that job. You apply for unemployment. Now remember, and this is where it gets kind of in the weeds, unemployment in most states generally says, most if not all states says, you are willing and able to work. So here you are, you left one job saying, I'm not able to do that job. In fact, down the road, maybe a little bit, you file for SSD. But in the meantime, you just come out of the job and you're like, well, I'm not useless. I'm going to get a job I can do, an easier job. And so, and this is what's in your head because you're a worker and you're like, I've got to pay my bills. I'm going to go get a different job that I can do. No longer lifting 50 pounds. So the person files for unemployment because they are willing and able to work. They just can't do that job. And they didn't lose that job through default. It was due to not being able to do that job, not because not being able to work at all. And unemployment might be available. So now they're collecting their unemployment. And then maybe a few months in, they hear through the grapevine this thing called SSDI. And hey, if you think you might be out for more than a year or more due to your disability, you could, consider filing for SSDI, even if it hasn't been a year yet. Okay. So then you file for SSD. You don't even have to talk to the SSA about unemployment, particularly the lower levels. It never comes up. I mean, it might, if they say, did you get any income through the year? You might want to say, I got unemployment from this date to this date. And let me just explain quickly how it is not inconsistent, by and large, to file for unemployment while also saying, I'm not able to work and filing for SSD. And here's why. SSDI, you're not saying you're unable to do anything. You're saying, I'm unable to do one of those 12,000 jobs that exist in substantial numbers in the economy on a full-time basis, 8 hours a day, 5 days a week, week after week after week for at least 6 months successfully. That's what you're saying you can't do, one of those jobs. You're not saying there's not some job you can't do that you can do. There could be there's some jobs that are really cushy. They're not in big numbers. That's why none of us have them. And they don't count for SS purposes in terms of, is there other jobs you can do? It's only the ones that exist in substantial numbers in the economy, substantial or significant. So when you're filing for unemployment, you're saying, I'm willing and I'm able to work. You're not saying, I'm willing and able to do every job on the planet, including the ones that lift 50 pounds. In fact, I can't lift 50 pounds, but I could do something else. I'm sure of it. And I'm applying and you're supposed to be applying. So the two are not inconsistent for most people, I think, who file for SSD. If you get someone who just usually due to ignorance, not due to malintent, can't do the job they're doing, maybe because they just couldn't do it mentally anymore or physically, but they feel very, very well able to do something else full time. And it's not just like, well, I don't even know if I could do a full time job because my back is humming whether I'm sitting or standing, and 8 hours a day of that, regardless of what I'm doing, it hurts. So I'd be better off with a 4-hour day part-time job, and I think I could do that. But the person who knows they can and then is just like winging it to see if they get SSD, that's kind of a different story. But that's not most people. And that's why I think most people file for unemployment, have all intentions of finding another job they can do. Then they find out, I really don't know that I would be able to do 8 hours. Even at that sit-down job, my back hurts when I sit at the kitchen table for breakfast. So a half hour is hurting, or I get winded when I walk to the mailbox. So I think people start to realize some of the more limitations they have once they're home and they're not in that tunnel vision of the job when you're at it and performing it until you can't. So unemployment, SSDI, not necessarily inconsistent. I will warn you, however, that if you go to a hearing, and I have not heard this in years, it's probably been 5 years since I've had a judge ask about this. And a lot of my clients have been on unemployment until they realized, maybe I really am disabled from most of those 12,000 jobs. Sometimes a judge will say, and I assume they still do it, I just haven't crossed my path. Yeah, I see that you were collecting unemployment while you're also claiming for the same period that you're claiming that you're disabled and not able to work. When you filed for unemployment, didn't you say you were able to work? Now, if a person's not prepared how to answer that question, I could see that would be a little bit of a, sometimes they'll say, well, I needed money, so I didn't know what to do. That's not really the full answer. The full accurate answer, and I've never seen an answer differently in reality, is that, well, at the time, Judge, I thought I was going to be able to do another job. There would be something I could do, and I was applying, and I thought I was going to try. And it's never been a reason to deny the person, because sometimes the judge will ask it. So not a bad idea to be prepared as to the reality of what probably occurred with you. I really thought I was going to be able to go back to work, or at least find that really unique job, that is kind of cushy enough for me. You can even say, if it's accurate, like I was looking for a flexible hour one and part-time, or maybe there would be like a morning hours and then afternoon hours so I could rest in between. Yeah, so I felt pretty sure I could probably do some job like that. And guess what? Those split shift jobs, they don't exist in substantial numbers in the economy, I don't think. And therefore that wouldn't have counted anyway. And it's not like you have to know that law when you're answering a judge who asks this question. You just say, I really thought I was going to be able to find a job I could do. I didn't realize that the kind of job I could do was so rare. And now you just kind of zinged it about that not being in substantial numbers, even though you're not quoting the law to him, because that would look a little pre-planned. So anyhow, I hope that gave you guys some information on that, because unemployment does make people worried. Or else later on when they file for SSDI, they go, oh, but I filed for unemployment. I'm like, no worries. Not a worry whatsoever. Okay. Hey, Beth is in the house. Hi, Beth. Good to see you. Gorgeous weather in Georgia, she says. So I will be live streaming from Georgia, Beth, with Mr. Jonathan tonight. Let's see. So feel free to pop in, people. Rolando says hello. Hello, Rolando. Okay. So we got Nina in the house. Nina A. Hi, Nina. I don't know that we met. But it's nice to see you. Nina says, this is the next question. My CDR diary date came and went. I'm 63 and no review yet. You got like 4 years. You know, if you know, Nina, that you are not medically improved, not that I don't want you to be medically improved, but that's the most comfortable place to be in terms of a CDR. And if you have continued to follow up with your regular physicians, including the specialists that you might have had before when you prevailed, as long as you're doing reasonable follow-up, it's not necessarily the aggressive follow-up that we were doing when you were applying. You were, because you're trying to prove and get something over a hump. You've got it over the hump. Now it's kind of like copacetic. So unless you know that there's some improvement that's going to show up in those records, or you're working now and you weren't working before, you know, that kind of thing. I don't like to see people worried about a CDR. You really shouldn't be, unless you've kind of slacked off on your treatment, or like in a way that would indicate improvement. Or if you had the kind of impairment that is, let's say it's cancer, and you're expected to, you know, go through a treatment and then it be in remission, then I could definitely see that's going to be a CDR, and probably, God willing, there's improvement, right? So unless there's something else that stemmed, like a lot of times some treatment for cancer really kills the stamina. It does something to our particular systems in there. And I've had a lot of cancer clients post-cancer who, what was the way one of them put it? I have a limited gas tank. And so maybe 2 hours of mild activity at home that she could do just fine. She could do the dishes. She can do the little, but 2 hours of doing stuff, then it's crash and burn for like a 2-hour nap. And it's like the body refuels itself. The brain, sometimes it's also the brain fatigue. And they'll, after being up for a while, they're starting to get a little foggy and maybe missing things. And just really, it's like a whole different change from 2 hours prior when they were refreshed, had just gotten up, had breakfast, whatever. So cancer can be a funny thing in terms of the law in this area, because if you're recovering, that's an improvement by definition. But there can be some sequelae that will continue on forever that might not even have started or wasn't noticed and complained about when you're in the throes of the treatment. And then it's the fact that you don't bounce back from this chronic fatigue, gas tank is only half full type of thing. Or that sometimes the brain fog, even though, yeah, sometimes the brain fog is just constant. Every impairment is different, but if it's that kind of impairment, I would expect to have a CDR. And if they're a little late, that's because they really did put the CDRs a year or two ago, probably 2 years ago now, on hold to direct those workers to handle initial and recon claims, appeals, and let those CDRs sit. And then they were trying to get them all taken care of. So it may or may not. And I will also say it's probably true that the last people they're going to go, like if they have to, it's like prior